The High Court has allowed a man to leave mandatory quarantine to visit his dying father, despite the son having recently returned from the United Kingdom. He is one of 18 out of 24 cases the Prime Minister says has been granted an exception under the lockdown rules.
Reading the judgment, there seems to be concern that it was an automated approach taken to requests on compassionate grounds. Information that I've received from the Ministry of Health, though, sets out that there were 283 requests for an exemption to the conditions of isolation having been received by the 30th of April, that 24 exemptions were sought in cases where a relative was dying or close to dying, of which 18 were granted. So that does suggest that there has been due consideration. That is advice I've received from the Ministry of Health, but I'm sure that they'll be reflecting on this judgment.
Oliver Christiansen was able to visit his father and spend 36 hours with him until he died on Sunday. Mr Christiansen arrived in New Zealand on April 23rd and initially planned to wait out the 14-day isolation period. But his father, who had brain cancer, was given days to live. This prompted him to ask for an exemption, which was denied, and subsequently led to the High Court ruling. Our reporter Anan Zaki spoke to Mr Christiansen's lawyer, Simon Foote QC, and started by asking him about the importance of the ruling.
Well, it was absolutely critical to Oliver and his family. These end-of-life issues that have arisen from the pandemic are incredibly tragic, and we all understand that if at all possible, both for the person who is passing on and for their immediate family, it means an enormous amount to give comfort to all of the family members when there's such a profound event going on. So it couldn't have been more important to Oliver and to his family.
Does this have implications for other cases?
Yes and no. Every case has to be looked at in its own particular circumstances. For example, here, it was important, I think, that Oliver was not symptomatic. He was placed in a low-risk managed isolation facility, and he was seeking permission from the ministry to visit his father at his father's home. So he wasn't. It wasn't required that he needed entry into a medical facility, for example. But having said that, the importance of this case for wider cases is that the ministry has a discretion under the Health Act order that requires people to be in quarantine when they arrive from overseas, and that discretion can be used where there is compassionate grounds and the person who is asking for the exemption is a low risk of transmission of COVID-19. And there's a further discretion even beyond that in exceptional circumstances. So that discretion plainly has to be applied in relation to the particular circumstances of each individual case. But what happened here was that the ministry applied that discretion very rigidly in relation only to certain categories published on the website, and were either unable or unwilling to look at the wider picture. And in my view, going forward, for similar cases, which there no doubt will be, the ministry needs to take a closer look and a more compassionate look at all these circumstances.
Some would argue this is a major health crisis and hard rules are necessary. What are your thoughts on that?
Well, it's undoubtedly a major health crisis, but that doesn't mean that hard rules must apply. In fact, I think it means the opposite, that we need to, or the officials need to have an open mind to all the frankly unexpected circumstances that can crop up from time to time. And the Health Act order specifically allows for exemptions to managed isolation on compassionate grounds where there is a low risk of transmission. and also in other exceptional circumstances. So there's no need to apply only hard rules. The law, in fact, is much more flexible than that.
And that was our reporter Anan Zaki speaking to Simon Foote